Okay. So we created this seminar specifically for small business owners, knowing that it's very difficult to juggle all the responsibilities that go with running a small business, and hoping that this would provide you with a quick summary of the compliance laws that apply to you and your employees. So employment isn't exactly easy, and being compliant in employment law is definitely a challenge. It's a challenge for me to keep up on all the laws that are out there, much less have you all know about it. So it's actually employment is actually a lot about having you feel that you're having control on your business and that you're making decisions that you feel are appropriate, and that hopefully the employees understand and feel the same way about. So thank you for taking the time to join me this morning. As Claire mentioned, a real quick little bio on me. Leslie Day, my company is Day HR Consulting. I'm in Lake Zurich. And I've had many, many years of assisting small and middle-sized businesses with all things that have to do with HR and their employees. I focus on giving advice to business owners so you can balance the risks associated with employment actions, your choices, so that if you decide to take an action about an employee who works for you, that you understand the pros and the cons, the risks that you may be taking, so that you're not, feeling sideswiped afterwards, that there was a component of it that you weren't aware of that might have impacted on your decision. As Claire mentioned, I also have taught not students at DePaul, but other HR professionals and managers at DePaul in their classes for getting our national certification exams. And that keeps me on top of all things that are best practices in the area of HR. My most common services to clients are one, an HR help desk. That's where companies can call me, management can call me anytime, email me when they have questions. They want to talk over an employee issue before they take steps, things like that. And then I do a lot of employee handbooks, which are a very good guide for your employees and help document what your policies and rules are for your business. Okay, a disclaimer before we get into the specifics. I am not an employment attorney, but I've taught employment law for 22 years at DePaul University and before that with Old Dominion. But on occasion, we do need to refer issues to employment attorneys. And when that serious situation occurs, I want to suggest that you consider two of our Lake Zurich area Chamber of Commerce partners. First, Buckley Fine is a law firm in Barrington, and Ron Kowalczyk there, as well as Kelleher and Holland in North Barrington, and Madeline Kelleher there. Okay, and lastly, we did either send you an email or Claire just put in the chat area here a link to a separate document that I'm providing you, which is a list of all the relevant laws that affect your business. So here we're talking about the new laws today, but I thought it would be good for you to see all of them. So believe it or not, there's 83 laws, critical laws that affect you. There's more little laws, but 83 was enough. So it's hard to keep up on these things for me, much less expect that you can keep up on that. You may want to print that out or pull it up as we're going. It may contribute to your understanding of our conversation. In the document, I highlighted in blue the laws that were new. So there's 83 laws listed. I highlighted in blue the ones we're talking about today. And then I also highlighted in yellow some of the more recent laws that I wanted to make sure that you guys were up on. Okay, and then as Claire mentioned, If you want to put any questions into the chat, I'm glancing over there occasionally. Claire is going to try to keep an eye on it too, so that we can, answer your questions. I would like to have everybody at the end of the seminar or today or tomorrow have your questions answered. So it's free to call me following the seminar or email me with specific questions you have about your business. I'm very happy to help. Okay, then let's get going into our content. So first is a quick one, just a reminder that the minimum wage went up in Illinois to $15 an hour, January 1st, the tip rate 9 and the youth rate 13. And then if you do have any employees in Chicago, it went up in Chicago as well. Okay, so before I start talking about protected classes, I would like to talk just a little bit about employment law in general. So Illinois is what's called an at-will like in quotes, at-will state, as are all the states in the US except for Montana. At-will is a state doctrine. And what at-will means generally is that an employee and a employer both can choose at will if they want to have each other working together. So the employee can decide at will when they want to quit. If they want to give notice, they don't have to. And the employer has the same ability to have an employee not work there any longer. They don't have to give a reason. They don't have to give notice, and they don't have to provide severance pay. So employment from day to day is at will. Now, I've never known a company that just willy-nilly said, okay, you're not working here tomorrow. But that's what at will means, that there's no obligation for proof of a problem for there to be an end to continuing employment. But we assume generally that there is continuing employment. So even though we have at will employment and an employer can have somebody leave employment anytime they want, at will does not protect the organization from allegations such as discrimination and or retaliation, which I'll describe in a little bit. And it also doesn't prepare and protect the organization from unemployment claims, which are always a big concern for small businesses because of the cost associated with those and the dollars that are spent by the state on somebody who's on unemployment and is being charged against the employer. So we like to avoid having there be discrimination concerns or beliefs by an employee, belief that they might have been terminated or something in a discriminatory manner or retaliated against in some way, and or have to pay unemployment for somebody that we felt that we let go, with having evidence of misconduct. Misconduct is the criteria that we use for unemployment claims. So we want to avoid these. Protected classes are the government rules that say that you should not consider protected classes or an employee's protected class when making critical employment decisions. So we should be making employment decisions based on valid work-related criteria, not based on a person's protected class, such as race, sex, national origin. And to be honest, those are all listed on the handout that I gave you, all the protected classes that apply for us in Illinois. And there's 21 of them. So there's a lot. So it's really good for you to know what the protected classes are. Illinois added this year 2 protected classes. So to go from 19 to 21, they added that you should not have as a consideration for an employment decision a employee's family responsibilities or an applicant's family responsibilities. That would be If the person is caring for a family member, has a responsibility to care for a sick, perhaps child, parent, has child care, school, picking up from school responsibilities. We would not want to have a adverse employment action, which would mean denying somebody uh, uh, consideration for an opportunity because they have family responsibilities. The federal government has tried to have family responsibilities be a protected class uh, for many, many years. The EOC, Equal Employment Opportunity Commission, has considered family responsibilities, but it has not really ever been formalized. So for us in Illinois, this is now formalized protected class. And then the second here, reproductive health decisions. This is an employee's choice regarding things like birth control, abortion, etc. Okay. I also do like to point out a common erroneous belief by small businesses is that they are too small to have a lot of these laws apply to them. And prior to about 3 or 4 years ago, you had to have 15 employees to have a lot of the discrimination type laws applied to a company or an organization. But about 3 or 4 years ago, Illinois lowered the threshold for discrimination type laws to apply all the way down to 1 employee. So for the last couple years, if you have even 1 employee working for you, you can have allegations of discrimination, retaliation that you would have to defend as an organization, as a business owner against. So there is no longer a little bit of freedom for small businesses. You have the same criteria as middle-sized and larger businesses for employee allegations of discrimination. Okay, so hopefully you have a little idea about what a protected class is and some of the legalities there. So historically, employees have had either 180 days or 300 days following an event to formalize a claim, either with the Illinois Department of Human Rights or with the federal government, saying that they feel that there had been a discriminatory issue with their employment with you. 300 days is, just a little bit short of a full year, 365 days. And this now has been extended in Illinois for Illinois complaints. So complaints that go to the Department of Human Rights in Illinois to 2 years. So it benefits the employee to have there be more time for them to file a claim. It increases the probability that maybe one of the witnesses to whatever happened that resulted maybe in them getting terminated, that maybe those witnesses don't work at the organization any longer or they can't be found. It can obviously have memories of the event get faded over time. And sometimes, documents are misplaced. So 2 years after you let an employee go, you can receive a letter from the state of Illinois saying that you're being charged with discrimination. So again, very good documentation is helpful, right? If you do have to defend an employment decision that you make. So please make sure you document when someone resigns, why they say they resign. Having it in writing is very helpful so they can't maybe change that later on. And then if you do let somebody go, having there be documents that support the reason, to show that the reason wasn't about race, sex, national origin, but because they were incredibly rude to a customer, and here's what was said, or they can't come into work on time, whatever that is, with thorough supporting information as you can. Get it together when you make the employment decision. pop it in the employee file. Hopefully you won't ever have to look at it again, but then you do have the information that you would need not only for a possible, it's kind of a long shot, right, to think you're going to have a discrimination claim, but you may also be wanting to protest, I'm sorry, a discriminant rate. You may also want to be protesting a unemployment claim, and those are much more likely to come up. And you're going to need the same kind of documentation to protest an unemployment claim as you would a discrimination claim in many circumstances. One of the reasons that we like to look at unemployment claims in small businesses is that it can be very expensive. If you were to have an employee on unemployment that you would let go, and they were on unemployment for 6 months, and they were making $40,000 or $50,000 a year, and you're probably going to have your unemployment tax rate go up so that they can get about $15,000 back from you over 3 years by having your tax rate raised. So get that $15,000. If somebody's on unemployment for 6 months, your tax rate would go up. Some of it is limited if you have very few employees, but if you have 10 employees or more, you're probably going to have enough employees that they can get the full tax amount back. So an unemployment claim and being prepared for an unemployment claim is very beneficial. I like to help clients with that. I think it's appropriate for companies. The state has given you the right to decide if you are okay with that person getting unemployment, or if you'd like to protest that and see if they agree at a hearing. Okay, so 2 years extension for an employee to say they have been discriminated against. Okay, pay transparency. Now this law only applies if you have 15 employees or more. So many of you may not have this one apply. And this law has to do with if you are going to be posting job openings on external posting boards such as Indeed, that as of the first of the year now, you need to add into the content of that posting, not just the job summary and what your requirements are. You need to give information to the applicant with a pay range. And I do recommend that you think about what would be the lowest pay you would provide to, the least qualified applicant, and what's the most you would pay to a highly qualified applicant, and have that kind of be your pay range. They're not happy with just coming up with kind of a bogus amount just to be vague. So consider, what would be the minimum that you could, conceive that you would provide somebody who was qualified, and the maximum. It also requires that if there going to be additional pay, such as bonuses or commission, that also be explained briefly. And then lastly, that there be a summary of the benefits that would be provided to the individuals, full-time versus part-time as well, if there's a distinction there, including, things like paid time off, if you're offering insurance and contributing to the cost of that, any kind of a retirement 401k, any benefits, because that will help the applicant weigh the amount of costs that they may be incurring personally for that position. Let's say that you don't offer health insurance. They may be then looking at the pay, the wage or salary that you're offering differently, because they know that they would themselves have to be responsible for finding and paying for health insurance. It also requires that there be an internal posting of positions that are posted that would be considered promotional. So that would be anything that's not an entry-level job that an employee might want to apply for if they knew about it. So here they're now going to know about it, that you would post the similar information that you have posted on Indeed or whatever for your employees. And this is going to be complicated because it doesn't include this pay range. So I suggest you talk about this, sit down, have your strategy clear, have the information ready for when you do have postings, that you can have agreement as to how you're going to handle that. Also, if you employ minor children, they have expanded some of the restrictions. So they have made it more restrictive if you're employing children. So a couple things on here. They have had the hours that a student between 16 and 18 can work down from 24 hours a week to 18 hours a week during school, and then to a maximum of 40 when they are out of school, so no overtime for minor children when it's summer or whatever. They need to be supervised at all times by an adult that's 21 years or older. A student that's 13 years or younger cannot work. There are some limited exceptions there, and I've given you the link for more thorough information here below on the slide. They have also prohibited some occupations and work environments, such as salons, barbershops, and nail services for safety and health reasons. Okay. So if you are employing some minors, you want to probably check out the rules and understand what the state would now expect from you. Employee files. I highly recommend that you have employee files, even if you're using a payroll service where you can immediately enter information into like a payroll grid. You still want to keep track in an employee file the dates that people's jobs changed or their pay rates, so that you can see what the rationale was for that pay increase or that promotion or job change. But employees do have a right to see and copy information in their employee file. So for as an example, you would put things in the employee file that the employee reasonably knows about. So if you're going to counsel, as an example, an employee on attendance, just verbally counsel them, you would want to write down the date that you counseled them, but you would not put that in their employee file. You would keep that in a separate file for yourself on the background or the reason for the counseling. But if the situation escalates and you give an employee a written warning that they sign that they received it, then that would go in their employee file. So we would want to have information in their employee file, such as their tax forms, maybe their original application form and resume, performance reviews, and then write-ups, documents that they signed would go into the employee file. So if you do have an employee ask to see or copy their employee file, chances are that means something, right? So I suggest that you would get advice from, an employment attorney, or talk to an advisor such as myself. There is a limited time window for you to respond, so you can't blow it off if they ask you. You want to not delay in getting some advice on how you would provide that information. Okay, pay stubs. So employees are paid, and you have an obligation as an employer to provide them with an explanation for what their net paycheck is. And they have formalized this a little bit more now at the state. You may use like accounting software, like QuickBooks. I don't know the extent to which a pay stub in QuickBooks provides this required information, but I know that if you do use a payroll provider for your payroll, that the pay stubs will always include this information. So it does require that you provide a pay stub every pay period, either hand it to them or have them have access to that through the online portal, through either your payroll provider or something that might be available through another software. Okay? And all this information needs to be on there. I do want to add also that in another law, the law that hit last year, requiring that employees be provided with some paid time off, that law also required that the amount of time off that they have been provided or either earned or accrued be itemized for them, and that the amount that they've used or have available also be available to them. So you have to have that. It might be on the pay stub, and if you have the payroll provider do the paid time accrual for you, which is often a free service, or the usage of that it's going to show up on the pay stub if you're using a payroll provider. I'm not sure if that also applies if you're using QuickBooks or some of the other small business accounting for your payroll. Okay, it also, and this is harder, the second is it does require that if somebody leaves your organization, that they have to get their final pay stub. And sometimes businesses who provide the pay stub electronically cut off the access to that information when the employee leaves. So I would suggest that you not cut off their access until after the W-2 forms are generated in the following year, so that they can get their W-2 form also through that payroll service. But if you don't use a payroll service, you need to give them, either mail it to them, email it to them. You need to get them their final pay stub with their year-to-date totals on it in the next payroll after they leave. And then lastly, you need to keep all these records, all these pay stubs for 3 years. Okay, next, mandatory attendance meetings. These are commonly called captive audience meetings. The state of Illinois made this law kind of camouflaging the fact that this is really about union avoidance meetings that companies have if their employees are considering voting to have a union represent them at work. So a non-union company where the employees are wanting to unionize, the company has historically had the right to have meetings on company time where they tell the employees, why they might not want to have a union come into the company and the pros that the company feels are important for the employee to understand. And these were done on work time, and everybody was at work. They had to go to the meeting. So this year they have now in Illinois passed a law that says that no, any kind of a meeting like this, and part of this camouflage that they put it in as religious and political opinions by the company, but it really was motivated about union avoidance conversations. So now employees can say, I don't want to go to these meetings. And they are protected from having any kind of a negative impact like a retaliation from choosing to not go to the company meeting. So that's, a pro-union law by the state there. Okay, so let's talk a little bit about I-9 forms. I think I would be remiss if I didn't mention that it's important that you have, for all of your employees, an Immigration 9 I-9 form completed, and that hopefully, you made copies of the documents that the employees provided you for the I-9 form. So the I-9 form is a federal form. It's been around for many, many, many years and just modified last year a little bit. It requires the employee to identify their work authorization, any visas that they may be on, and they would do that on their sign that part of the form on their first day of employment, no later than their first day of employment. And then also they need to provide documents to the company proving that they are who they say they are. So the first part is it would be a picture ID, like a driver's license or something that's generated by a like a governmental agency or a student ID or something like that. And then second, that it would be a document that would show that they have the legal right to work in the United States. There's many documents that could meet that requirement. A common one is a Social Security card. Could be a birth certificate, an original birth certificate with a seal, like a Frenchy seal on it, showing that it's an authentic original birth certificate. And then a passport would meet both of those requirements. So in that case, they would only need to provide one document if they have a passport that they wish to provide you. And we suggest that you make copies of the documents to show that you did make sure that these, look like they were the real deal documents when you accepted them. Often, we take the I-9 form out of employee files and keep it in a separate file, maybe by last name, alphabetically by last name, depending on how many employees you have. And that is so that if you were to have a governmental agency representative come to the work site and they did ask to see the I-9 forms, you're not having to pull all the employee files out and find that information. It's recommended that you keep those in a separate folder so that they are easily obtainable. And then also there is a requirement that if an employee was to leave your employment, that the form be shredded after a period of time. So you want to maintain these I-9 forms as the government requires. So the I-9 form is the only legally mandated form for employees. So it's important that you get that form for everybody. With everything going on right now with immigration concerns, lawyers are recommending that you pull out your I-9 forms for your employees, look them over, make sure that you've got one for everybody. If you don't, it's suggested that you get advice again, either from an employment attorney or somebody like me, on how to do that properly and not have there be any challenges to the method that you got those forms and how you would actually date them now and things like that. So this is kind of like a fine tuning that they did this year on I-9 forms, mostly about the anticipation that there might be some higher scrutiny on these forms with raids on the federal government seeking individuals that don't have the legal right to work and or may also have some criminal history. So the first requirement that was added in here was that if the company or organization was to be notified, probably by the federal government, okay, that they were going to be having some kind of an inspection or that their I-9 forms were being formally audited, that the employees be notified. A second, it requires that if a specific employee was to have the federal government, it could be maybe a Social Security or the IRS, they send out what's called a mismatch or no match letter. Sometimes they've done it like every third or fourth year, saying that the employee in their records, when taxes are sent in, the taxes are going to a Social Security number, let's say, that doesn't match with the name that we're sending it to through payroll. So those are called no match or mismatch letters. Now we are formally now obligated to tell the employee that we received something like this or a specific inquiry about a specific employee. Employees should not be let go or have any negative issue until they have had a chance to resolve. There are sometimes discrepancies in records, so we want to make sure that they have a chance to fix anything that might have been in error. And then there are some organizations that use the federal E-Verify system. That is a software that the federal government has created that gives further verification after the I-9 form that the applicant has the legal right to work in the US. Now, Illinois has historically made it difficult for employers to use the E-Verify system, and some companies and organizations are required to use it based on some grants or contracts that they have with the federal government. So if you are considering or using the E-Verify system, this law does have some additional mandates, kind of like hoops for you to jump through in order to continue to use that software. Okay, employee agreements. An employee agreement is generally considered the wording for a contract. So a regular employee agreement might be something like you have an obligation to maintain confidential information as confidential. That's not a contract. That would just be an agreement. Okay? But if you do have this agreement go beyond that to include clauses such as a non-compete obligation or a non-solicitation obligation, those then become legal contracts. And those need to be generated by an employment attorney in the jurisdiction that you are hiring that person in. They need to know about what the specific county, often county by county, rules are for these contracts. So quickly, just to explain how it works, a non-compete agreement is where the company has an employee sign that they understand that if they were to leave employment, they could not go work for a direct competitor. They do like to have these be very narrowly focused. And often there's geographic windows that you can't work for a competitor within 20 miles or specifically list businesses that are direct competitors. And there's a period of time that applies for. Often it's about a year. And then there are some states that have made non-competes illegal. The federal government has tried repeatedly in recent years to limit and exclude the use of these. But businesses often feel that their proprietary and confidential business information needs to be protected from getting taken and given to their competitors. Okay, so that's a non-compete. A non-solicitation can be a separate agreement, or it can be combined in with the non-compete. A non-solicitation is less restrictive and is many times much more employee-friendly in that it simply requires that the employee not solicit any of the clients that they might have been acquainted with and gotten to know because they were working for you. And often non-solicitations in Illinois can go for, I believe, 3 years. And they are not together. They can be separate, as I mentioned. I have a lot of clients that choose to do non-solicitation clauses. They don't want somebody who's in sales leaving their company and then going to a competitor and then soliciting all the clients that they got to know that are through them working for you. So that does protect in that circumstance very well without having to have this geographic location and restrictions on employment at all. This is simply a restriction on hitting up on your clients and your employees as well. It also does restrict them from soliciting your staff to go work for perhaps like their new company. So Illinois has had a law for a number of years here that identified that non-compete agreements in Illinois could only be legally done for employees that are making at least $75,000 or more a year. So a non-compete, the individual has to be making at least $75,000 a year. For a non-solicitation, a lesser, the minimum salary or pay is down at $45,000. And that is so that there's not, your hourly trades worker or retail or fast food hourly employee who's having one of these employment contracts. So here they have added another specific restriction for the construction industry. So they're saying that clearly somebody who's not a manager, so they did eliminate from this managers, supervisors, professionals in the construction industry, but focusing on non-salaried type employees that either way, no matter how much they're making, the construction industry would not be able to legally have non-compete or non-solicitation agreements. That's a pretty big deal. And then I'm not sure that I understand what this next one was. They also said that if there were issues affecting veterans or first responders, somewhat having to do with mental health services. I don't know exactly how that applies. Maybe we'll get some clarity on that down the line. Okay, so if you have a non-compete or non-solicitation employment contract that you use for your employees, you would need to make sure that it's compliant, and that would be by contacting the employment attorney that created it for you. You don't want to get these from the internet and then just copy them. You would need to have it so that it's enforceable in Lake County or Cook County or wherever the employment, your business is. These need to be generated by attorneys. I do not, I can't. I'm not an attorney. So I would suggest that you get these things refreshed and understand that these are a deterrent to a certain extent for an employee leaving and thinking that they can use the information they learned while working for you. But you may want to actually enforce it if you had an employee take away your best client or your best employees.
Hey, Leslie.
Yeah.
I'm going to give you a chance to have a drink of water.
Uh-huh.
I just wanted to remind, because a lot of people came in a little bit after you started. So for those of you on the call, if you scroll back up to the top of the chat, you're going to see the slides, and you're going to see the Can't Fire in Illinois document that Leslie has shared. If you need me to put those links in again, I can. I'm not sure. Hopefully everyone can see those. And again, just if you have a question, Leslie's willing to take them as she goes along. So make sure you put those in the group chat, because we kind of have everyone muted just to get out, block out any distracting background noises and whatnot. So just make sure you put those questions in, so that it can be as informative as possible for you. And then I'm sorry, did you tackle if the I-9 is required by, for
Yeah, I
contracted
just saw
employees?
that.
Yeah,
Yeah, I just
yeah.
saw that. Yeah,
So
so
yeah, if you want to.
yeah, this I'm glad you asked that question, Laurie. I am going to talk about independent contractors in a little bit, but I-9 forms are only required for employees. Okay, so if you're having like an IT company come and take care of your computers, and that person who comes occasionally and takes care of your computers is a contractor, um, but they are employed by their IT company, then they would have given their I-9 document to their IT company. So often what I'm assuming that you're asking here maybe is if you have a one person individual independent contractor who is supporting your business. And there are laws that are right on this next slide that we're going to talk about that I want to summarize. This is an area for a lot of legal exposure for you as businesses to have individuals that are helping you that are not employees. So the answer to that question is no. You would not want to ask for any information about their legal right to work in the U.S. as an independent contractor, at least today. Okay. Thank you, and I'll give you some more information in a little bit here on as I get through this slide. Well, I might as well just do it right now. So at the bottom of the slide, I mentioned that you really do want to keep an eye on the rules the federal government has on independent contractors. So when you have an individual help your business, you have options. You can hire that person and put them on payroll and have them pay, their federal tax, state tax in Illinois. You would be as an employer paying FICA and MedFICA, which are Social Security and Medicare taxes on the employee. You would also, as an employer, have workers' comp insurance coverage for the employee, as well as taxes for unemployment. Okay. And generally the taxes, the federal taxes for social and Medicare is about 7.65 cents for every dollar that the employee is paid. So add 7.65 cents for every dollar with whatever the cost is for your workers' comp and unemployment tax. And that's the cost that you have for an employee versus having that individual help your business as an independent contractor. So as an independent contractor, you don't pay those taxes. You don't necessarily have them on your workers' comp policy, although it is highly recommended that you have independent contractors on your workers' comp policy. Talk to your insurance broker about adding that in. And then no taxes for unemployment. So there are times when a business might think, well, it's cheaper for me to have a person come on as an independent contractor than a employee. Well, we're not talking a lot of money difference. Okay, was my point here. It's not a lot of difference. However, there is a huge risk that you are assuming by having the decision to have this person not be hired, but being brought on the assumption that they're a legal independent contractor. We use the 1099 form to identify that individual as a independent contractor. They provide their social security number or additional information on that form, and we would provide them in January each year a W-9 form as well. So you do still formalize your relationship with independent contractors in most cases. Otherwise, you're kind of paying somebody cash. Now, the federal government, the state government, they all want their tax money and don't want businesses to be having non-taxed services. So they do try to restrict the circumstances under which a independent contractor assumes responsibility themselves for paying their taxes. So an independent contractor has assumed their own responsibility for federal taxes, state taxes, as well as paying for their own retirement and Medicare costs. Okay? And this is a ball that goes back and forth between administrations as to how tightly or loosely independent contractor use is controlled. So if you do have independent contractors that you use that are not employees of other businesses, as I mentioned, like that IT example, I really suggest that you get advice, again, from an employment attorney or somebody like me, so that you're understanding what your risks are. Many times there has been bad advice that businesses have received, and they look at it simply from a cost-saving standpoint without the understanding of some of the risks associated with identifying or misclassifying an individual as an independent contractor versus an employee. One of the examples of how this could be bad would be that if you had an employee, if you had this person as an employee, they might be eligible for medical insurance. But as an independent contractor, they're not. So if that independent contractor was to have a health condition or an accident, it could be that they would, in retrospect, say, well, shoot, I should have been on as an employee. I should have had health insurance, and then go after you for the fact that that was not provided to them as an option. So you don't want to just, naively be in this circumstance with independent contractors, okay? So please be aware, last fall, there was a tightening of the independent contractor rules. We haven't seen anything yet on that being modified by the Trump administration. Okay, then just on a couple extra laws here that I want to point out that didn't require a whole lot of information, but I just wanted to mention whistleblower. In Illinois, there's a law, for a long time, that says that if an employee feels that their organization or their business is cooking the books, is falsifying information that's critical for citizens of Illinois safety, that they are protected from being retaliated against if they go and tell the government about this information. So that's a whistleblower. That's somebody who knows confidential stuff about your business, and goes to tell the government with the expectation that the government will look into it and hold you accountable. There's been some vague understanding here as to if that person, instead of going to the federal government or the state government or some government, was to just come to management and say, hey, look it, I'm concerned about this. If they also were protected from being retaliated against. So because retaliated against generally means some kind of a negative adverse employment action, like getting terminated or being cut off from overtime or getting sent to a icky shift or having their pay cut, being excluded from training, things like that. So this whistleblower claim adjustment in Illinois, it hadn't been looked at. I hadn't seen anything on it for many decades here. But they have adjusted some of the key words that are in the whistleblower law. So they have added in there that if a reasonable person would find an issue that was negative or adverse, or that it was perhaps retaliatory by the company after they came to them, that would specifically qualify if they were, one, to disclose or threaten to disclose any information to a supervisor, manager, owner, board member, inside the organization. So they were clarifying that if they were to go to anybody in the organization or the board of directors, that they would be protected from what a reasonable employee would consider a negative outcome. Also, if they were this one has me thinking about current scenario, reporting an employee suspected of actual citizenship or immigration status problem. So if somebody was to go and say that one of their coworkers was perhaps not legally working here, that would be protected from retaliation. And then lastly, intentionally interfering with a former employee's employment. So I think that means like giving a bad reference that wasn't based on factual information. So these are interesting. I think we'll have to see how that shakes out. So they did formalize some stuff on whistleblower claims. Next, BIPA is the acronym for biometric information. This is most commonly applies to us in HR with time clocks, with companies using time clocks for their employees that use like a fingerprint, a handprint, an eye, iris, a scan, and saving that biometric information into the system, and having that saved information be maintained securely and managed. So like if the employee leaves the organization, making sure that from the software, the biometric software, that is deleted, their information is deleted. And so, keeping all this biometric information managed by, the HR department or somebody. So Illinois is one of only a few states like Texas and someplace out northwest like Oregon or Washington or something. There's only a couple of states that have enacted laws on the responsibility that companies have to manage this biometric information that they're getting in their time clock. Okay, and there's just been an incredible amount of lawsuits that some specialty attorneys have had great success with in proving that companies were getting this biometric information and not managing it and not keeping it confidential, proving that they're managing it properly as per the law. So this BIPA law has been around for, gosh, I don't know, 8 years, I'm guessing. And so for the very first time, we had a little bit of a restriction. So this was a good law from Springfield, that they were limiting some of the dollar amounts and claims that a company would have if they weren't using their time clock properly. So it made it so that if a person would have one claim, so let's say for a time clock, you clock in at one time a day, you clock out at the end of the day, or maybe you clock in and out at lunch. Well, those could be 4 separate clocks, and there could be a claim historically 4 times. So what they're saying under this new law is no. Let's just limit this quantity to something that's really more based on usage. So a little bit of a restriction here on BIPA. I do highly recommend that if you do use a time clock or any kind of a business system that uses biometrics, I know there's some customer service type retailers that use that for like customer coupons and things like that. Illinois is not a good state for that. Indiana's fine, Wisconsin's fine. Illinois has some requirements that you have to be pretty careful about, or you're going to get sideswiped with a very expensive claim. So if you are using biometrics in any way, I highly recommend that you get advice and make sure that you're understanding how to manage that information properly. Okay. Next, the Illinois Secure Choice program has been around for a number of years. It is a state-funded retirement savings plan for employees at companies where there is not formal retirement plans like 401ks. And currently, if an organization has 5 employees or more, they need to formally offer their employees the ability to have money taken out of their paycheck and sent down and invested in this state secure choice plan. Okay, it's after-tax money. It's not like a 401k where it's pre-tax money. It's after-tax money, and you as an employer would be obligated to take, whatever the employee chose to take out of their paycheck and zap it down into their account at the state secured choice program. It does not require any contribution by the company, so it is free for the business to use, other than there's a cost for the ACHs of the employees' contributions. And you do have to have proof that you offered the retirement plan. So they did fine tune this a little bit. One, they said that the company can create like an open enrollment, maybe similar to what they do for their medical insurance, where they only do it once a year and it's very formalized as to how they offer it. The area that I was more interested in about this new law is that it excludes IRAs as being considered a retirement plan that would make it so that the company would not have to offer Illinois Secure Choice. Historically, if a company had a simple IRA, I believe that they did not have to offer this secure choice program, but it looks like they are now taking that option out. It was something like an auto enrollment IRA. So I do suggest that whomever you have if you do have a IRA for a retirement plan for your employees, talk to your retirement plan professional. This may be too new for them to really have a lot of information on yet, but it may be that it will not exclude you from having to offer this Illinois Secure Choice plan to your employees as well as your IRA. And you may also out of that say, look, let's just get a 401k. Illinois is making this too hard now. And so then I would suggest that you contact, any of the many Chamber of Commerce, financial planners, to look at the cost and the benefits of a formalized 401k. If you're a nonprofit, often a 403b is the choice. And then lastly here, there was also something about healthcare worker background checks. If you are an employer in the medical field and you have mental health workers, the law did clarify information about criminal records checks on these employees and applicants, and that you would be obligated to not hire certain individuals with problems with their background checks or history with a DCFS problems or on some kind of a sanctioned list. Okay, we're just rolling right along here. Okay, then those are we've completed the laws that apply for January 1st, 2025. There were some plan laws that were either delayed or put on hold or have some kind of an injunction against them. The first one is having to do with the Fair Labor Standards Act, which has to do with minimum salary levels for an employee to be and a job to be exempted from overtime. So as you know, you generally have employees in two big clumps. You either have hourly employees that you pay for every hour they work. And if they are working more than 40 hours in a week, you have an obligation to pay them time and a half overtime for those additional hours. Then there are some higher level jobs. Often we call them white collar exempted jobs that you can pay on a salary and assumingly then not pay overtime if they work over 40. These jobs historically, and by law, I'm sorry, are usually executive and management positions, meaning that they have at least 4 full-time employees reporting to them. So they're like a manager, a supervisor. Or another category is that the job requires that the person have a 4-year degree in the area that they are working. So like an engineering degree for somebody who does engineering stuff, or an accounting degree for somebody who does accounting stuff. So not just a vague a degree, 4-year degree. Then there's also an exemption for outside salespeople. So outside salespeople means that they're not selling from their office, or they're not a retailer where customers come to their facility. Outside salespeople are under the kind of antiquated concept that salespeople go to the customer outside of the office to make sales. The law has always allowed that those folks can actually be paid 100% commission and not even have a salary. And there's also an exemption for highly skilled computer folks, such as programmers. And then there's a lastly, kind of like a catch-all exemption for jobs that are administrative. And these are higher level administrative positions where the individuals in the jobs actually make decisions of significance without getting approval from like a boss or having some pre-made like a corral of acceptable authorizations. So it would have to be somebody who really, has the independent judgment for some decisions. So those are the categories for a job that allow a position to be exempted from overtime. And part of that has required that a minimum amount of pay be afforded to each person in that job. And it currently, well, before July of last year, was about $35,000. And this has been another one of these balls that's gone back and forth between administrations. Originally, many years ago, it was $24,000. The Obama administration tried to raise it up to about 47. Then Trump, the first time, cut that back to the current level, which is about 35 now. Now the Biden administration raised it to 43 as of July 1st, but then also was raising it to over 50,000 as of January 1st. And that additional raising to over 50 was halted by a judge's injunction. So we are still sitting with this Biden law partially blocked. I would expect that perhaps this is something that the Trump administration looks at again, as they did when they took over from the Obama administration. But that is kind of in limbo right now. So legally, if you have an exempt employee that is, getting a salary and meets the duties requirements, as I mentioned, they need to be paid, close to $44,000 as a minimum. So that's on hold. And then the next one has been a back and forth battle as well. Is the U.S. Department of Treasury required about a year ago, maybe I think it was originally like 2 years ago, but it took a little while to have it come to due date. It required small businesses to register a lot of information about the ownership of their business on a website created by the Department of Treasury based on the fact that they know that there are some small businesses that are the recipients of illegal funds, either from or to bad international organizations. So they decided to have everybody that's a small business person register, so they could try to find out who these bad actors are. And this was also has an injunction on, so that has been stalled. They asked the Supreme Court just a week or two ago to decide if the Supreme Court thought that it should move forward. The Supreme Court decided that they were not going to get involved in that one. So they kind of said, no, we're not going there. So this is also currently being held up by an injunction. On the FinCEN website, it says that a company can voluntarily give that information to the government, making it clear that we're the real deal, and we're not a front for a foreign bad actor. But that was to go into effect now, and that is on hold. Yep, I lost my arrow here. Hold on. Okay, and then coming up in a year from now, there has been a lot of talk about artificial intelligence, and Illinois already has a law that they are now fine-tuning starting a year from now on the use of artificial intelligence in hiring and making employment decisions. The federal government has also been pretty active in recent weeks, opening up what some Biden era restrictions had been on AI, based on some of the partners of the Trump administration. So we're going to be having dueling laws here again, where the federal government may have some laws. The state may also have some laws that we are going to be needing to balance. If you are using any screening tech tools through some of your job posting sites, like Indeed, you are using artificial intelligence. Those screening devices are using artificial intelligence to exclude certain applicants from employment considerations. So that is where the rub is here for us in HR to a great extent. You would want to make sure that you understand the criteria that the screening service is using to exclude candidates. There has been lawsuits that show that they have been using criteria that, one, either were not legal, or two, which the employer found as problematic, like that they didn't like. So in HR, there's a lot going on with artificial intelligence. So if you are using any kind of screening like that, I do suggest that you first figure out what you're doing, what it's using, how it's impacting you, what the criteria are for the screening. Decide if you want to continue using it, and then perhaps get some advice on moving forward to make sure that you're complying with Illinois' laws on that. I have not seen where necessarily these organizations share with you that you are legally responsible for their tool. So they make the tool, they have this software, artificial intelligence built in, you choose to use it, and you are legally responsible for any allegations of discrimination as a result of the tool. So keep an eye on that. Okay, so getting close to wrapping up here a little bit. Some guesstimates maybe on what we're seeing with Trump era changes. Wow, it's only been a week. What a whirlwind. So we are expecting, some of which I already mentioned, that some of these Biden era regulations are overridden, and that we go back to whatever the Trump regulation was before it was changed by Biden. That would be affecting some OSHA, safety, and EPA employee pollution type environmental issues. As I already mentioned, with the wage and hour law, the minimum salary, we're probably going to have some kind of a decision by the Trump administration as to what the minimum salary should be for exempt employees. I already mentioned independent contractors. They had just last fall finalized a tightening of the independent contractor rules under Biden. We'll have to see if those are then going to be undone. And as I mentioned, employment contracts, those have been mostly managed by the states. But last year there was an attempt by the federal government to control employment contracts, kind of under the guise of it being a monopolistic restraint in trade. So we may have that looked at again. We also have seen in the last week some elimination of some very long-term, like decades-old regulations. The biggest one in the last couple of days was affirmative action plan. So let me tell you a little bit. I think there's a lot of confusion out there about what affirmative action is. So affirmative action is different than EEO. So EEO, Equal Employment Opportunity, is applies to all at a federal level for 15 employees, Illinois at 1 employee. And EEO means that you would not exclude an applicant or an employee from an opportunity, like a promotion, let's say, based on their protected class. So you would not exclude an applicant because of their race, sex, national origin, all those 21 reasons that I listed. So employees should be in the pool of people that you consider for hiring. They shouldn't be excluded from the pool under EEO. And the law never says that the employer should pick any particular individual in this pool. That is the obligation of the company. They can just pick within that pool who they wish to hire. But they should not exclude individuals from being inside the pool. Okay. Now, when affirmative action came out, and this was enacted way back during like the Vietnam War by President Johnson, okay, what it affirmative action created was a very small group of companies that sell products or provide services to the federal government. Just those companies that want to get government monies have a higher standard for hiring 4 categories of individuals in protected classes: minorities, females, the disabled, and veterans, including disabled veterans, that they have a higher expectation for hiring and promoting and training individuals than your basic non-government subcontractor does. So if you're not a government subcontractor, you don't have an RFP and a contract with the federal government, you're not an affirmative action employer. You're probably an EEO employer. Okay. So affirmative action was required, meaning extra action was required by these government contractors to get qualified minorities, females, into that pool that I talked about, that pool of candidates that you consider for an opening. Instead of just having the pool that came through Indeed or a sign out in front of your business to get candidates, affirmative action required that the company notify additional sources to try to find qualified minorities and females to be in the pool. Okay. It still never identified that you had to hire any particular person. But what we've seen, I think, over the years is that different organizations have been more assertive about employing and promoting and training minorities and females as a result of affirmative action plans. So the affirmative action program is controlled by the federal government and therefore is under the auspices of the president. So the president announced in an executive order, one of many, obviously, but that affirmative action programs are not currently to apply to minorities and females or based on sexual orientation or gender identity. So of the 4 that I said that are part of affirmative action, minorities, females, disability still applies, and veterans still apply for affirmative action. Affirmative action employers have a formal plan that they have to generate every year and follow, showing the extra steps that they're taking. So they would still be taking extra steps to get into that pool, disabled candidates and or veterans, but they would not be taking extra steps to find qualified candidates that are minorities and females. So I thought maybe I could give a little bit more clarity as to what the affirmative action component of what just happened was. Okay? And that was just done, I think, like this week, that this hold was put on affirmative action plans. Then also a lot of controversy here on diversity, equity, and inclusion. This kind of piggybacks a bit on affirmative action. EEO has to do with individual employment decisions, but DEI is more of an overview of an organization or company, talking about their commitment to having a diverse employment group, including all employees in all of the activities of the organization. Some of these programs have actually prompted having there be extra effort, again, kind of like affirmative action plans, for these non-government contractor organizations. So it kind of looks a little bit like affirmative action, but it was not within the government subcontractor realm. So that's what some of the stuff is going on right now with DEI. As a small business, I would, I'm not quite sure many of you have these formalized DEI programs that many of the major corporations are in the news about currently. You have probably seen on the news that we're having some raids in the workplace. There were raids that were done through all the prior presidents' eras. So there were raids during the Obama administration, the prior Trump administration. There have been raids that have gone on in the Biden administration. But the huge focus now, so this is increasing by many-fold the quantity of raids that are going on. And the raids have been predominantly so far, from what I've understood, going after individuals at their homes in some places. I haven't seen a lot about them going to workplaces yet, but I know that that's going to be out there, especially in certain industries where there is more likely going to be folks that do not have the legal right to work in the U.S. there.
Hey, Leslie.
Yeah.
I just wanted to, I'm going to put a link in the chat here for everyone. Scott DeMuth, who is part of our Government Affairs Committee, just sent us a resource guide for employers on what to do if immigration does come to your workplace. So that might be helpful in there. We'll have that on our website soon, but yeah, that might be a helpful link to copy down.
Very good. Very good.
Never know when it's going to happen.
Yeah, and so for that, it's really recommended. And I imagine it's in this guide that, again, you pull out the I-9 forms. You should have one for every employee. You would also want to make sure that it was filled out well. I think this is a form that many times gets shoved into the employee file or scanned, and it's not really completed thoroughly. There are fines that go with that. But this is a very tumultuous time. You may have employees that are very concerned, right, afraid. So I would suggest empathy on our part, uh, and um, uh, and make sure that your documents are in order, including your I-9 forms. Okay, good, good, good.
So we're almost at 10. I want to give people a chance to ask questions.
One more
Did,
slide. You know, we did
okay.
want to offer them the posters, Claire. So hold on, I
Yep.
got to
Okay.
get to it. There is one more slide here. There are posters that you are obligated to have, you know, your employment posters. So there are federal posters, state, and in some cases, Chicago municipality posters. Um, there are free posters that the chamber is providing you on their website. Claire gave you the link to that. Here it is here as well. So she put it in the beginning of the chat. So
I'll put it in. Yeah.
you can print these out for free and put them on the wall with your other posters, or put them into like if you have an intranet where you keep all of these access for so that all employees have access to them. I did not see any federal posters that needed to be updated. So the chamber is providing that for you for free. So that's it for me. I also, for the chamber, provide all of you guys with a free question. So if you want to contact me at the conclusion of the seminar, email, phone, it's free. I do this for the chamber members. I don't want anybody here having a question that they don't have an answer to. So I really, really like answering questions. So that's it for me. Thanks.
Thank you so much, Leslie. That was just a lot of information, as you said. Woof. And
Yeah.
there's a lot. There's a lot for business owners to be able to understand and know about. And we get that, it's probably not in your time frame of your day to be able to go out and research these things. So that's why we do workshops or seminars like this. I did want to mention that we do have an advocacy page on our website. It's lzacc.com/GAC. And there'll be updates on things like the posters and things like that.
And I think you were going to put the slides there too, Claire, correct? So they would have access to these slides.
Yep. One of the biggest things that I do want to call to your attention, actually two things, is if you have not paid attention to a little blue card that you might have gotten in the mail, there's a Visa MasterCard settlement that's taking place, and it's for anyone who has accepted Visa or MasterCard from January 1, 2004 to January 25th, 2019, which I'm assuming is a lot of you. One of our former members who's moved out of state actually brought this to our attention that it's a real thing. The former member had a business here in Lake Zurich, and they submitted a claim and they're getting $8,000 back, and they haven't lived in Lake Zurich since probably about 8 years. So I am putting it is on our website, but I'm going to put this link really quickly into our chat as well. I know we're killing you with links, but all of this stuff can also be found on our website. And then so I would encourage you to take advantage of that and just see. It can't hurt, right? The second thing is that we have there is a new grant out from Illinois for capital and infrastructure. The award it can be anywhere from $10,000 to $245,000. So if you or know of a business that is looking to expand their technology or expand their facilities, or anything, I would encourage you not to shy away from grant opportunities like this. I know they can be overwhelming, but if you have any questions on that, you can call me, let me know. There is a link as well to that. And it can't hurt. So if there's any questions before we hang up, let's go ahead and unmute yourself.
Can I share the immigration details once again?
Yep.
I think, you know, as a business, I would just suggest, there's that link. Is that what it was?
Yeah, that's the immigration link.
Okay. That you would, you know, focus on your I-9 forms. If you have a question about the I-9 form, email me or call me. Happy to answer any specific question you have.
I have one more detail, and that is about our scholarship program. If you visit our community tab on our website, there's a scholarship information there, and this is also for you guys as employers and for employees. So if you're looking for additional training or further education, and you would like to have your tuition or price tag covered at least somewhat or in part or in full, don't hesitate to fill out that application. It is based on it's available for high schoolers and college kids, but it's also available for adults, employers, employees. So take that into consideration as well. We have those funds that we have been collecting for the past couple of years, and we give out scholarships every year or award dollars every year. So a lot of options for you guys. All right, looks like there's no other questions. So Leslie, are we all set?
I get it. Thank you. Thank you very much, Claire, for sponsoring this and for all of you taking the time. I hope this was valuable for you, and the chamber is here to assist small businesses with issues just like this. So look at us as a resource for all the questions you have for running your business.
Yes,
Oh,
Kristen, there will be a copy of the recording available. I'll get that out to you guys when we're done. Well, when it's done.
Yeah, and you can share that. This is a free seminar, so share that with other, of your professional friends that you think might, benefit, coworkers, things like that, from this information.
All right. Thank you guys. Have a great day. And if you guys are, there's an American Place casino business after hours tomorrow night. If you're going to that, have fun. It's a multi-chamber with about 12 chambers. So lots of new people to meet. And at that, we will conclude and have a great rest of your day.
Thank you all.
Bye-bye.